All right, welcome back, everybody. This is IGTV, and we're on with attorney Andrew Tallmer. And Andrew is a lawyer with Concord Law School of the Kaplan University. Andrew's also been researching and talking about constitutional law for as long as I know him, and that's back when he was an attorney with the NYPD's Legal Bureau. So, Andrew, let's continue along those lines. All right, you were about to talk about the automobile exception. All right, go ahead.
I'd like to make the distinction, Joe, between the Gantt decision and the automobile exception. There are two ways that law enforcement officers can search vehicles, well, at least two ways, without a search warrant. And one is called the search incident to arrest, which we talked about with Gantt. The other exception is called the automobile exception, otherwise known as the Carroll Doctrine. Because of the mobility of the automobile, it's impractical for police officers to obtain search warrants, to tell the driver, just stay here on the side of the road, we'll be back in 3 hours with a search warrant, don't go anywhere, don't hide any evidence, just have a cup of coffee, we'll come back in 3 hours with a warrant and search your car. The court, as way back as 1925, thought that that was kind of silly. And so they developed an exception to the search warrant requirement called the automobile exception, and it's simply this. If officers have probable cause to believe that a vehicle contains contraband, they can look anywhere in the vehicle where the contraband could be, including open or closed, locked or unlocked containers. This would include the passenger compartment as well as the trunk. And the only restriction on officers here is that the search has to be conducted in a public area. That is, if the car is on someone's driveway, they cannot use the Carroll Doctrine. They would need a search warrant or another exception to search the guy's car. And the other rule in Carroll to remember is that the police can only look where the contraband could be. So if the police have probable cause that there are narcotics in the vehicle, obviously that's going to be an extensive search of anywhere in the vehicle where narcotics could be found. On the other hand, if the police are looking for a larger object, let's say, for example, stolen artwork, 4 by 6 inches, or a piece of work of art, or 5 by 10, or whatever, the police could only look in those areas of the car where the stolen art could be found. I guess the lesson to take away is that the Gantt decision does not affect Carroll. And so if the police in Gantt had probable cause to believe there was contraband in Gantt's car at the time they made the arrest, then they could still conduct the search under Carroll and many cases after Carroll, which have upheld the doctrine.
Thank you, Andrew. I appreciate that. Now, when we get into all of this, like I said before, I'm always looking to crosswalk this over because, sometimes people say, hey, what are you talking about? Search incident to a lawful arrest and the automobile exception and all this stuff. How does that apply to me? I'm an information technology guy. I'm sitting watching a firewall. I'm doing this. I'm doing that. I'm not driving a car. This doesn't make any sense to me. How do I apply it? Why don't you give me a little, give them a little background on that?
Joe, I think it's what you touched on before. The walls of privacy are crumbling if we at least take these two cases, Murphy and Diaz, into account. That is, what the owner of the PDA/smartphone/cell phone might think is a protected private communication may no longer be, once the object is seized, incident to a lawful arrest. What this means for the information technology person, the specialist, or whoever else is involved security-wise, is that you might be able to get evidence from the police where before you would need, say, a search warrant, or perhaps a subpoena, or some other kind of judicial authorization. The other thing to remember is that if the search is authorized incident to arrest, then the law enforcement no longer has to worry about the eavesdropping laws, which are quite strict, both federal and state, requiring warrants usually where we're talking about protected electronic communications. And everyone agrees that text messages, for example, are electronic communications, emails, etc. But if the police have lawfully seized the item and the courts are going to determine that the search incident 2 may be made, of course, without a search warrant, then we no longer have to worry about going to court to get judicial authorization. And if the police can do the search without a warrant, that means that the items, the evidence can be recovered in plain view, and the police can then let know a non-law enforcement security personnel what they found out.
Right, and we know just from our own experiences here at InfraGard that information security officers, CIOs, CSOs, and security directors rely very heavily on the cases that are developed from law enforcement when they set up their own rules and procedures and when they conduct internal investigations within American and non-American corporations, you know, that are based here in the United States. So when they look at all these laws and, you know, the case law that's being developed right now with Murphy and Diaz, you know, they're kind of looking at that, or they should be anyway, and they should be saying to themselves, oh boy, we better look at Murphy, we better look at Diaz, and maybe the chief counsel in our corporation had better start talking to people about the use of these devices, the protection of them, the privacy of them, and what those expectations are. All right, because they are evolving.
Correct.
Yeah.
And the general counsel also is going to have to consider whether these two cases are likely to apply in his or her jurisdiction, whether that person thinks that the high courts of their state are going to adopt the same reasoning. Of course, if the U.S. Supreme Court weighs in, then we no longer have an issue about it. The extent, if any, that the case is put on where within the phone can be searched. It doesn't appear upon our first initial readings of the case that the courts would put any restriction on what can be searched incident to arrest, but future courts might say, well, the police can look here, there, and there, but they might draw the line somewhere else in terms of certain information on the phone. We'll have to see.
Right. So this is evolving case law, and this is, I guess, this is what you would call cutting edge as technology takes foothold in American lives and how American case law is developed over time. These are two cases that are going to be, I guess, like Belton in many ways, right down at the foundation level.
That is correct. And as we were talking about before, with technology ever improving, what's going to be the next great thing? Would Murphy and Diaz apply to an iPad? The answer is presumably yes, recovered incident to arrest. But what is Steve Jobs or whomever going to come out with next in terms of the device? Would the courts view intrusion, police looking into that device any differently, or is the Murphy rule, the Diaz rule, is that going to be the same for all devices, recovered incident to arrest?
Yeah, I think you really articulated that well, because I wasn't taking that taking this point into account either. That as these cases bubble up through the local district courts, and then they go up into the appellate, regions. That will be the real test, and then to see which one of the cases that finally bubble up there and make it to the Supreme Court and become the law of the land. All right, so this has been very, very good, very enlightening. I certainly appreciate it. Was there anything else you wanted to bring up in Blaine or in Tompkins or any of these others?
Joe, there's lots of case law out there, but I think each of those cases would take us probably a separate segment to get through it. There have been major adjustments, for example, in the Sixth Amendment confession area, in terms of police officer ability to question people after they've seen the judge and have a lawyer assigned. The Burgius case is a very important Fifth Amendment case where the Supreme Court, this is Burgius versus Tompkins.
Sure.
The Supreme Court decided very quickly that when somebody is arrested, waives his or her Miranda rights, does not request to remain silent, does not ask for a lawyer, the police conduct a 3-hour interrogation where the person says nothing, and then at the end of 3 hours, the officer says, "Should we pray?" And the defendant says something like, "I'm sorry to God that I did it," or a confession like that. The issue for the Supreme Court is whether he invoked his Miranda right to silence by being silent for 3 hours. And the Supreme Court, in I think a major victory for law enforcement, said no. The person has to say to the officer, either I want a lawyer or I don't want to talk to you. It has to be unambiguous, and someone remaining silent is quite different legally from someone saying that they don't want to talk to the police. So after somebody waives their rights, the police can talk to them as long as they wish, and the fact that someone is mum for a long time, like 3 hours, does not mean the police have to stop.
Okay, I think that was great. It gives some people some insight of what's bubbling up around. Andrew, we look forward to talking to you again on IGTV as some of these other cases come up, and as we expand into some of the other cases you gave me as well. We won't go into that now, but we can go into that later on another session.
Sure thing.
All right, thank you, sir.
Thank you.
All right, bye everybody. We'll see you soon on IGTV.